Okay, so I've been asked to sort of present on the family aspect of the Zambrano judgment. So just to start off by saying that the court has repeatedly noted in its case law that union citizenship is intended to be the fundamental status of nationals of member state, and I would say that Zambrano has gone one step further in achieving this EU goal and in recognising a real and coherent status for citizens of the union. So just to briefly summarise the aspect of the case that's interesting from my point of view and from a family law point of view. So the ECJ has found that the non-EU national parent of an EU citizen child has the right to reside, and not only the right to reside but also the right to a work permit, so that the EU citizen child can fully benefit from EU citizenship. So from a family law point of view, this judgment stands to reason when one actually looks to the core of family law, and if we take into consideration the best interest of the child and to have the company care and parentage of parents. And the Advocate General actually mentioned as well in Article 24.3 of the Charter of Fundamental Rights that every child shall have the right to maintain on a regular basis a personal relationship and direct contact with both his or her parents unless contrary to his or the best interest of the child. So, in addition to that, the Advocate General also makes reference to Article 7 of the Charter of Fundamental Rights, the International Covenant on Civil and Political Rights, the Convention on the Rights of the Child, and the European Convention on Human Rights. Now, it's a pity that the court actually doesn't go into detail on any of that, but it's the opinion itself is quite telling. So the question from the family law perspective to me seemed quite simple, at least in the sense that would there be a breach of the fundamental right to family life if the parents were deported? And the answer is obviously yes, since the consequence of a deportation of the parents would most probably see the EU citizen child, or children in this case, that they would have to leave Belgium after having been born into that society and integrated and after having been raised there from birth. So, as I said, the court unfortunately didn't really engage in a profound discussion of this. So, what then did the court base its reasoning on, or how did it reach its decision? I mean, the court makes reference to previous case law. And if we consider the Carpenter and Schuman, which I won't really go into because Johanna has already mentioned them, although those cases were criticised for creating sort of dubious links to the treaty, I think it stands to reason that the court were to follow Carpenter and Schuman. And Carpenter, the link being the father's economic activity and the mother the primary caregiver, and then in Schuman the link between citizenship and free movement. So, I mean, even though these cases were criticised for stretching the boundaries of the scope of EU law, we have to sort of consider what's essentially involved here. The economic goals of the EU essentially require the free movement of goods, services and people. But people are not robots, and that's what the Advocate General actually put forward as well. I mean, when people migrate, they take with them both their mutable and immutable characteristics, be that civil status, religion, culture, legal conditions, whatever that might be. So they also take with them their families, and these families deserve legal protection and a legal basis upon which they can rely to exercise their right to family life. So it's within this realm that Zambrano actually takes a significant step, essentially recognising that the movement is not a prerequisite to trigger the scope of EU citizenship. And as Johanna mentioned, expanding the scope of EU law to sort of internal situations. And the effects of this on family law then can be quite significant. So basically within the scope of my research for my PhD, I tried to investigate the reception of judgments passed by the European Court of Justice and attempt to decipher the impact that EU law has on domestic legal systems in relation to family law. So in preparing this presentation, I had attempted to have a look at the reception of Zambrano in Ireland. And the results are quite telling, I guess. Well, as telling as they can be. It's only 2 to 3 weeks since the judgment. So I think first of all it's important to notice that all member states who made a written submission, and the Commission as well in the case, said that the case didn't come within that what was envisaged by the freedom of movement. Ireland obviously argued the floodgates argument, which I guess is not surprising based on their preoccupation with this issue of citizenship and the issue in 2004 that led to the referendum and the revocation of Jus Soli. So it wasn't surprising, at least to me, and I don't think to any other Irish sort of lawyer either, that 2 days after the Zambrano judgment, a High Court judge openly called for a judicial conference to discuss the implications of the ruling, and also urging the government to take a formal position on the judgment as soon as possible to provide clarity in relation to a number of other judicial reviews that were pending and are still now pending before the courts. And moreover, in the same week that the judgment was released, there were calls that the Irish government revoke the deportation orders of parents of 20 Irish citizen children who were forced to leave the country as a result of the parents' deportation order, and also the countless other number of parents of Irish citizens who had left the country in the last 5 years. So why then was there such a frenzy? So the judgment certainly calls into question the Irish government's policy of deporting parents of Irish citizens in the last 5 years. Most deportations are based on the reasoning that the family unit can still be preserved if the citizen child accompanies the deported parents back to their state of origin. And this is in fact true, the main crux of family preservation resting on the company, care and parentage of parents, and therefore implying physical proximity. However, Zambrano and essentially its interpretation of EU citizenship has shed new light on these types of cases, and by doing so it has afforded weight to the protection of the family unit in the host member state. So that was the actual response of the state, the Irish state. The Department of Justice last week released a statement on the case, and the main points it highlighted are the following. The first, that obviously it stressed that the judgment applies only in cases where the child concerned is a citizen, but the court stressed that anyway, so that was quite clear, stressing that it was a domestic matter. The Minister for Justice then went on to stress that the government would take a proactive approach to the matter, and as opposed to waiting for the Irish courts to deal with the issues on a case-by-case basis. And then in view of this, the Minister has initiated an urgent examination of all the cases that are pending before the courts, of which there are about 120 at the minute, so as to decipher as quickly as possible whether the Zambrano judgment is relevant. And the Minister has also said that parents of Irish children who have already been deported, so any parents in the last 5 years that have been deported, can now reapply to return to Ireland and have their situation reviewed. So I guess we'll have to wait for the results of the investigation for I don't know how long, but I think in conclusion I would have to say that the primary law of the European Union has again granted quite strong protection to the family, and as we have seen from the reception in Ireland, the potential of this reasoning to infiltrate the domestic systems and strengthen the rights of the family unit as a whole. There are, however, some questions I think that remain to be answered, and I don't really have answers to them, but I'll bring them up anyway. The issue in Zambrano obviously revolved around a traditional family based on marriage. But we all know that the family has, and its composition has changed significantly over time. So if a similar case concerning new family types, let's say, were to come before the court or even national courts, how would they deal with the issue? I guess considering the best interest of the child, a court probably would be likely to get a similar decision. And again, I think it's important to note that the Advocate General noted in paragraph 40 that the National Court, actually the Belgian National Court, has in the past and continues to refer to EU law for the definition of who is to be considered a family member. And seeing as the EU, I mean, if we look to the Citizens Directive, it has broadened the definition of the family to include registered partnerships. and it seems to be quite sort of open, or at least a little bit more advanced, as opposed to maybe some national courts, in recognising the family as an EU player and not just individuals as factors of production, as I have said. Other questions like, what if the parents divorce? What happens to the parents' rights of residence once the citizen child reaches the age of majority? And what about maybe parents, or a parent who is not involved directly in the daily upbringing and care of the child? Does the case apply to guardians as well? So there's just a few questions that kind of came into my head whenever reading the case, and it's likely that some of these issues will have to be determined in the future. And then just in conclusion, in relation to citizenship itself, I've been sort of doing some research recently on sort of different categories of citizenship. So market citizens, consumer citizens, labour, worker citizens, so these categorisations that have been made. As a result of Zambrano, this is sort of a question that remains open. Can we now talk of a family citizenship, or just simply citizenship, EU citizenship, or